Be sure to state your full name for the record before proceeding. With that, we'll call then the matter involving the marriage of Carol DaCosta and Joseph DaCosta, and counsel for the appellant, Joseph DaCosta, may proceed.
Your Honor, if it please the court, I'm Michelle Lowney MacDonald Shimoda. I represent Mr. DaCosta in this matter. Mr. DaCosta is actually here in the courtroom. Mr. DaCosta and Ms. DaCosta were married. They purchased a home. They had 2 children. They were raising their children. They had absolutely no court orders affecting their families. And then Ms. DaCosta decided to divorce and use Minnesota Statutes 518 in order to do so. Minnesota Statutes 518 is the dissolution of marriage statute, and it's a statute that's designed to terminate a marriage. I have presented briefing to the court that our statute, Minnesota Statutes 518, was unconstitutional as applied in this case and is also unconstitutional, period. Some important points about this case. First of all, Your Honors, there were absolutely no custody orders and no child support orders until the final decree after that 9-day trial. So in my brief, I talk about what are called fundamental rights. Fundamental rights that are not given us by the Constitution, but preserved by the Constitution. It's like the air that you breathe. Now, this is a de novo review of the statute. It's also under the guise of strict scrutiny. And I would ask Your Honors to take, the bold step of, at a minimum, declaring that in this particular instance, the statute was unconstitutional as applied. As you know, and as the record shows, Mr. and Mrs. DaCosta, after their marriage and after they had children, provided each other and the children with a home, food, clothing, all the necessities of life, education, health care. By education, I mean we have public education at this point. By health care, I mean they took care of their children when they were sick. I don't mean health insurance, but they did provide health insurance. And they also were able to provide their children with love and companionship. And that was uninterrupted until Ms. DaCosta decided to divorce. What happened, Your Honor, and it's by the record, and there's a very extensive record, is that Mr. DaCosta was working. He had been with his children every day of their lives, taken care of them, done the things that a parent does, had the home for them, which was in their joint names. And he had, he got served with papers. He got served with papers that were dated months before. What he ended up doing was going home like he had every day after work. He had talked to his wife that morning, as he did every day after work, and he went home, and his doors were locked. He couldn't get in, and his wife, as the testimony will show, had changed the locks on the door, parked in the middle of the garage so that he couldn't get in, and called the police. The police came. Mr. DaCosta went home. He left. And following that, Following that, he left. He did not contest. He was just going home. And as the record will reflect, if he had seen a letter from Ms. Fitzpatrick that said, please stay away from the home, she's getting a divorce, you've been served with papers, he would have just stayed away from the home. He wasn't given that opportunity. The next day, Ms. DaCosta filed an order for protection relating to himself and the children. Now, orders for protection, they're pursuant to 518B. It's extraordinary relief. Okay? It doesn't even apply in this particular instance. But Mr. DaCosta hired an attorney, and he went to he didn't hire an attorney. He went to the first hearing. Ms. Fitzpatrick was not present at that hearing, and Ms. DaCosta decided that she wanted an attorney. So again, days go by without him being able to see his children or be at his home or contact their mother. And there is a situation where there's an OFP hearing. Now, we need to remember that the paperwork was just served. There was no answer yet. There was no opportunity to answer. He had 30 days to answer. And at that...
Wait. 30 days to answer on an OFP?
No, on a petition for, I'm talking about the petition for divorce.
Okay, because
So-
I thought you were talking about the OFP.
No. He responded in kind and went to the court hearing. And at that court hearing, it was before referee Mulrooney, and referee Mulrooney decided on an unscheduled hearing to order the no contact. Now, therein...
Agreement between counsel on that at that hearing, wasn't there?
Yes, there was an agreement between counsel to that order for no contact. Okay.
Wasn't he
So-
waiving through his attorney?
No, he was not waiving anything through his
Why not?
attorney. Because it's up to the judge, really. I mean, we're talking about judge error here. It's up to the judge to really recognize what he was doing at that very moment. Okay, in a family law matter, okay, at the very onset of a case, the judge was actually taking an agreement that wasn't even a custody agreement, wasn't even a child support agreement, and had no place in family law, a no contact. No contacts are part of the harassment statute, and they're part of the family law statute. So it's up to the judge, really, to be concerned about a parent's fundamental rights, to understand, and to actually not accept agreements that are contrary to fundamental rights in the Constitution.
But this wasn't a pro se party. This was a party represented by an attorney.
Right,
It
yes.
was an agreement
Yes.
between the parties.
Yes, so if we want to rest on that and say that he agreed and the judge ordered that his fundamental constitutional rights be violated, then we can do that. Do we call it malpractice? What do we call that? We call it a judge not being caring about the deprivations that he did.
Counsel,
Yes.
constitutional rights can be waived.
And there was no waiver of any
There
constitutional
was a
rights.
sign, the attorney signed the order and agreed to it.
They didn't waive any constitutional rights. And constitutional rights are fundamental rights. They're to preserve our Constitution. Our Constitution doesn't give us rights. It preserves the rights that we already have. So judges can't be signing unconstitutional orders like that. It's very, very clear. And and obviously, as applied, this court must find that as applied, that order in a family law statute that carried through the entire proceedings and then ultimately was incorporated into the final order. What is that? Again, it stems from the fact that 518 is to terminate the marriage. And what happens is, in a final decree, and most of them are settled, we get a termination of the marriage, and then we get multiple orders that what I believe are unconstitutional injunctions, basically. A do this, do that, orders that you can't even appeal, that you need to modify. So the judgment is simply the termination of the marriage. All of the multitude of orders that occur are injunctions ongoing. Do this, do that, ongoing deprivations that are agreed to.
In the world you're envisioning then, what would happen in a situation where parties can't agree?
Well, in the world I'm envisioning, let's look at the case of Lapel that is in my brief, okay? When parents have children and they exercise their fundamental rights, it would only be if one of the parties was depriving them of that fundamental rights, that back and forth. In this case, Mr. and Mrs. DaCosta, when they were married, were not depriving each other of their fundamental rights. Mr. DaCosta was able to see the children, participate in any activities he wanted. So the world I envision is that only if you are deprived of your rights would there be that compelling state interest like in Lapel. In other words, Lapel, there were no court orders, as I recall in Lapel, either until the mother decided to move with the child and deprive the father of rights. So in Lapel, they consider that a compelling state interest, that this father who had rights to the child, who was seeing his child on a daily basis, was needing to was being deprived. So in other words, you would only have a compelling state interest if you were being deprived.
Well, isn't that the status of this case at the time you got involved? Because you already had this agreement that had been reached with counsel that set up a situation where his ability to see his children had been affected.
Right. The status of this case was the court getting involved in depriving rights. Do you see what I'm saying? In other words, by virtue of the petition and by virtue of the arguments of counsel, however that went, the court actually enabled a deprivation of parental rights instead of looking at it as a deprivation of parental rights on the part of Ms. DaCosta. So that's why it was necessary for him to engage in the litigation, obviously, because he was at the lowest of low. First of all, what we need to remember is because there were no custody orders until the end, or the beginning, if you say, they're divorced and now they're moving on to a different realm in their relationship, well, the court was recognizing, obviously, Ms. DaCosta's fundamental rights because there were no custody orders. She was just going to have the kids, and he was going to have no contact with them.
Well, but either party could have brought a motion for temporary custody or gotten an order from the court.
He went to trial. Why would she want to bring a temporary custody? She already had the order that she advocated and wanted through the end of the trial.
Were there any pretrial orders whatsoever? Were there any?
Before that, and I'm calling it, this is the fruit of the poisonous tree, before that, no contact order, no orders whatsoever. No orders whatsoever were involved in their life. There was just a petition that had been served, and it wasn't even answerable yet. 30 days hadn't gone by yet for him to even answer the lawsuit. And then to interject something as serious, whether by agreement or not, the court should have recognized that this was a severe deprivation of fundamental rights. And again, we don't go into court to say we have rights to custody now. Our culture does. We go into court so that the court reinforces our fundamental rights. That's what the Constitution does. It doesn't give us rights, it reinforces All right. So any other questions about that? Because there's a couple of other things I want to point out to the court.
Well, I know you're almost out of time on your initial argument, but you'll be able to do that or address any response to the respondent during your rebuttal. So you've got 10 seconds if you
Okay.
want.
Well, I'll rest on my brief then for my piece on the portion of the statute that immediately there's an order for a custody evaluation. And I think what we're doing here, Your Honor, is we have loads of U.S. Supreme Court jurisprudence that say we cannot enter the realm of family unless there's a compelling state interest. And I submit to you that because somebody wants to get a divorce, that is not a compelling state interest to be able to deprive one parent or the other of rights to one degree or another. Thank you.
For the respondent then?
May it please the court, my name is Shannon Fitzpatrick, and I represent the respondent in this action, Carol DaCosta, who is sitting behind me. Ms. DaCosta is the mother of the...
I suspect that tapping is some kind of maintenance on the heating system or something. It's not related to somebody trying to get into the courtroom. May proceed.
Okay. Ms. DaCosta is the mother of the two 10-year-old twin children that are the subject of this action. And it's really important to consider that there are children involved in this action because this court is given the duty to protect the children. As the Flint Court stated in 1895, the primary object of all courts, at least in America, is to secure the welfare of the child and not the special claims of one or the other parent. This case involves the welfare of the children, not the special claims of Mr. DaCosta. Mr. DaCosta, nowhere in his brief does he really focus on the wellness of the children. He focuses solely on his own desires to be with his children. The
But
children are being
doesn't some of
harmed.
that go to the argument of whether he's a fit parent?
Yes, it does, Your Honor. And in fact, that is the primary fatal flaw with appellant's argument. He asserts the fundamental rights of a fit parent. His brief is replete with statements of law, statements from various cases, Troxel, Suhu, Rothmiller, all of which address the fundamental rights of a fit parent. The trial court found that Mr. DaCosta was an unfit parent, and that renders the constitutional argument moot.
Those words, did you say unfit or fit?
Unfit. The court found that Mr. DaCosta was unfit.
Tell me where that is.
Yes, Your Honor. It is in a footnote. Addendum page 40,
Thank you.
finding 184.
But really, what the referee was saying at that point was that by virtue of finding that visitation needs to be supervised, and needs to be supervised at all times, not half the time as had been recommended by the evaluator, that implicit in that was almost a finding of unfitness is what it seems the referee was saying to me. But
Well, the court at that point was referring to the constitutional argument that the appellant had raised, and so the trial court was specifically addressing the constitutional argument and saying, even though appellant didn't define what unfitness is or fitness is for the constitutional purposes, I'm going to deem that it is the standard that we used for restricting parenting time to supervise parenting time. And so there was a finding of unfitness, which has never been challenged. No other definition of fitness has been proffered. Once the trial court found that Mr. DaCosta was unfit, and he was unfit because the children were endangered physically and emotionally by being alone with him. When he was with them, he emotionally harmed them to dramatic degrees. And so even though the context that the court was ruling on at the time was the issue of supervised parenting, the court recognized that there was a constitutional argument and addressed that. And we believe and we contend that that finding of unfitness is the key to this case, because given that he alleges the rights of fit parents, but yet he's unfit, the issue is moot. He lost the right to
Is it moot or does he lack standing?
both. Maybe, sometimes I don't understand that. They're kind of related terms. It's moot in the sense of his constitutional as applied argument is moot, but he lacks standing to argue that the statute is unconstitutional on its face. He lost standing when he was found to be unfit, and therefore he's not part of the class that would be injured by this statute. So there's two fatal flaws that arise from that finding of unfitness, which has never been challenged, I should say, and it stands.
Let's just assume for a minute that
Sure.
both parents are fit, and a court is faced with this constitutional challenge as to the ability of the courts to act on parenting rights or decisions under the dissolution statute. What kind of a world would that leave us with?
I'm sorry, I'm not sure if I understand your
What would
question.
happen where then you had two fit parents who couldn't agree on custody?
Well, I think that's one of the problems, and that's why we need a statutory scheme. That's why I don't think that the Troxel and the Suhu analysis, which applies to third-party visitation cases, it doesn't work when you've got two parents. How are you going to decide between two parents? You're going to give, and they talk about you have to give deference to a fit parent. Well, you're going to give deference to both fit parents? Where does that leave you? What does that do?
That's what happens in every divorce case.
Exactly.
Generally, 99% of the time, you have two fit parents, and the court then has to adjust the parenting time accordingly.
Exactly, and the statute provides ample factors for the court to analyze. So it's not just the court's just going to make a decision as to what he or she thinks is in the best interest of the children. There are very specific guidelines for determining that. And I mean, actually, Minnesota is recognized for having the best, most enumerated, most specific best interest statutes of almost any other state. Something I just learned by moving out to Massachusetts. They admire our best interest statute. But in any case, the fitness argument, it depletes, eradicates any basis for even looking at the constitutionality of the statute. There's a lot of flaws with this.
Stating that because in a footnote, there's an allegation or the court found that this fellow was unfit, he doesn't have then the right to contact with his kids, visitation with his kids, summers with his kids.
No, Your Honor.
If he's unfit, does that mean he's a danger to these children?
He's a danger. He was found to be a danger to the children.
Danger to the children, why does he have any contact?
He was found to be a danger to the children if unsupervised, when unsupervised. And that's why they put the requirement. He can have contact. He can have time with his children. That wasn't taken away. But it was conditioned on supervision, and that supervision was necessary because without it, these kids were endangered. And there's ample evidence of his atrocious conduct that was found to have already emotionally harmed the children. So he has rights, even as an unfit parent. For example, he has the right to due process, procedural due process, and he was given that. He was given more than that. He was given 9 days of trial, which was extraordinary and extremely expensive, and that's one of the reasons this case is so frustrating, because we have been litigating this case at enormous cost, depriving the children of assets and property that would otherwise have gone to benefit them. And we're continuing to litigate this, even though there's no merit to any of the appellant's arguments. There's no merit to his argument, for example, on child support. It's been long recognized that an initial order of child support found in a decree can go back to the date of, at least the date of commencement of the action, if not to the date of birth. He had no argument on that. It was a frivolous argument that has cost us time and money. Same thing with his argument.
Frivolous in the sense that that they gigged him for 20 grand.
I'm not saying that the dollar amount is frivolous. I'm saying that his argument is frivolous. He doesn't cite even any authority to say that the court can't award past support. And if you look at the authority, it all says you can. So to me, that's why I say it was a frivolous argument.
Well, wouldn't there also be a need for a motion for new trial or amended findings to preserve the issue for appeal on that particular issue?
Yes, Your Honor. In fact, that is a problem with a number of his other arguments. For example, the custody evaluation argument. The appellant at trial argued against it on hearsay grounds, but did not make a motion for a new trial, and therefore that hearsay objection was not preserved for appeal. The same thing happened with the financial report, the expert financial report. He objected on the grounds of Fry-Mac, which is the standard, you need to determine whether an expert really is an expert. But he didn't preserve that issue. That's an evidentiary issue, and he didn't preserve that by arguing for a new trial. So on appeal, he argues for the first time hearsay. Same thing with conduct-based fees. It's a frivolous argument. If I can even understand his argument, he's saying that my client should not have been awarded conduct-based fees because he was forced to litigate. That's an illogical argument, and there was so much evidence. There's just ample evidence of all of his conduct that did nothing but to unduly prolong this case. And so child support, custody evaluation, financial report, conduct-based fees, all frivolous arguments not supported by any authority. Same thing with his arguments on the financial end. They're baseless. They have no merit. For example, the finding of the non-marital interest in the rollover IRAs. The issue there was whether the dividend and interest appreciation in an IRA is marital or non-marital. The trial court correctly held that in a retirement account, which is different than an investment account, a retirement account, growth of the account due to dividend reinvestment or income reinvestment is not marital. It's different because in a retirement account, you can't access those dividends. You can't access the interest income. It has to stay into the account until retirement time, at which time it's taken out and taxed. And so appellant completely ignores the distinction between retirement accounts and investment accounts. So that argument is baseless because the authority that we cited, Gottsacker and Baker v. Baker, clearly indicate that in a retirement account, interest and dividend reinvestment maintains its non-marital status. His argument regarding the investment account and the annuity is perhaps even more frivolous because he actually misrepresents what happened. The appellant claims that the court did not distinguish between interest and dividend appreciation and market force appreciation. But the court did exactly that. The court did distinguish between growth and apportioned it. If it arose from non-marital assets, then it was non-marital. If it was due to the marital side, then it was marital. So that we even have to argue or point out to the court that he misread the trial court's findings is just It's just another example of a frivolous argument. Your Honor, I think at this point, unless you have any additional questions for me, I will rest on my,
I have a
Brief.
child support question again.
Sure.
You know, maybe I couldn't find this in the record, but was there a specific order ordering child support early on?
no, Your Honor, and that reminds me, I want to address,
And that's where we get into the $23,000.
so as in many divorce cases, you don't file a motion, you don't need to file a motion for temporary support. You can wait until the end of the case, and then at the end of the case, the judge can look back and determine, well, how much have the parents contributed to the support of their children? And then at the end of the case, determine what child support should be and when it should start. And in this case, the child support order commenced with the time that the appellant stopped paying any financial support.
Wouldn't it be better practice to get that temporary child support order in place immediately so that you don't have this situation where all of a sudden you dig into a property settlement and award that in lieu of child support?
There would be problems with requiring, it's not easy to get a temporary support order. It's not, because, Your Honor, the courts are flooded with, they're so busy. If you call up
They
today
know
to
that
try
it
to get a
makes-
motion.
They know, I don't care about the courts. The courts have to get to us if you bring that motion. Am I right? Or can the court just say, I'm not gonna get to that issue?
No, the court must, but you can't even bring that motion until you've had an initial case management conference. And then when you do, after the initial case management conference, you can try to schedule a motion, but motions are going out 4 or 5 months, and so
Well, this
it
has
shouldn't
gone
be a
out 4 or
requirement.
5 years or 6 years, hasn't it?
Not that long. Well, he
Long
was,
time.
I guess I hear Your Honor's argument that it would be preferable, perhaps preferable to have an early child support order, but it shouldn't be required because a parent should recognize his or her
On the
obligation
other
to
hand,
support the
he could
child.
have brought the motion to have his child support established himself.
And we tried to, by the way, we had all the facts and we tried to stipulate, but we couldn't get him to stipulate. We had to go
I
to
know
court, we had to
your
litigate.
time is up and you've answered my question.
Thank you.
Your Honors, first of all, what you need to understand is that I brought a constitutional challenge to the statute, that it was unconstitutional as applied. So ultimately,
Let's assume we
what
find-
ended up being the...
Let's assume if we find in your favor, what happens? What's the next step if we find that that 518 is unconstitutional?
Well,
Where do we go?
The relief would be that you would order joint custody and reasonable parenting time as the parties do, okay? In other words, it's only because Mr. DaCosta has been deprived that he's actually engaging in the litigation. He was not deprived, nor was Ms. DaCosta deprived before this litigation commenced. But that was my world, okay? We have 1,000 pages of regulations that only apply if you litigate, if you bring a petition, okay? Outside of that, people do have these fundamental rights that they usually honor with each other, even when in court with agreements. You talked about also the child...
But didn't that happen here? Wasn't there an agreement right at the outset?
Yep, let me show you that. That agreement had no custody provisions in it. It had no finding of endangerment, nothing. No child support provisions. This wasn't a family court agreement. This was an agreement that the judge took on so that everybody could move on, and it was unconstitutional. That is the poisonous tree, so to speak. So we can't say that somebody, because somebody's rights were violated by a judge.
Counsel,
Okay.
wasn't it entered into in lieu of the motion for an order for protection?
No, it
Yes,
wasn't.
it was.
No, it wasn't in the order for protection was dismissed.
Right,
This was
because
a-
of the agreement.
Okay.
Because of the no contact agreement. So are you suggesting they should have gone forward and litigated the order for protection instead?
Yes, yes. If it was in that realm, yes. And as we pointed out, because we litigated the order for protection here, I don't think there's one finding that you'll find, because she actually was able to speak on it. But I'm very concerned that there's a misunderstanding that fundamental rights are how you operate in the world, and then when a lawsuit happens in family court, suddenly the parties are trying to deprive one party or the other of custodial rights and of property rights. Now, to Justice Stauber's point, then you go back and because if you have these rules and you say, oh, he should have paid support when he was actually supporting the child. We presented to the judge $90,000 because they wanted it, of support to the child. He actually owned the home that they were living in. So what we do is end up trying to monetize the relationship. And there was no custody order and there was no child support order. So how can somebody that agrees to some order that's unconstitutional and a judge sign it? If that's our standard, it's very sad.
But counsel, if we don't have an agreement and the courts can't get involved in settling disputes between these people, what do they duke it out in the courthouse parking lot or what?
No. Well, usually that's what happens. When people are married, they agree to a schedule on a day-to-day basis. It's just but I understand what you're saying, and Justice Stauber too. What it is about parenting time. So, in other words, what we're doing is going into court, not just saying that my rights have been deprived, I haven't been getting enough parenting time. We're going into court to get rights that we already have inherently. And that's the problem with our statute. Once we are, and without a compelling interest, and that's very important, okay? There was no compelling interest in this case for the courts to determine even custody.
Counsel, is the best interest of the children a compelling interest?
No, it's not a compelling interest. The best interest of the children is actually subjective standard that has been determined in Troxel not to be appropriate when you're dealing with fit parents. We were dealing with fit parents. There was no petition that said he was even unfit, and I showed the courts that. The petition was just a standard, everyday divorce petition where she wanted sole legal and sole physical custody. That's what that petition was. And there was no allegation of danger, there was no allegation of unfitness, and the orders can't be justified. When she says things like and I think my time's up. Your Honor, I would ask that the orders be reversed, that the parents be awarded joint custody with reasonable liberal parenting time, that the attorney's fee order be reversed for the reasons stated in my brief, that all of the property that was determined during the marriage be divided, and that the child support arrears be vacated. Thank you.